Hello, POL 325 class. Hope you guys are all doing great out there and not getting too stir crazy. I'm sure it's a little bit difficult on you, and hopefully these lectures give you some respite and some interesting insights to things. Grace, I'm sure you're watching this and eating a chicken sandwich or something right about now. So try and pay attention as I go over some important things. And what we started the last time that I spoke was this overview of gender discrimination. So the last lecture pretty much gave you a history and a cultural and economic and social analysis of gender discrimination in the United States. Today what I'm going to do, as you can see by the outline we gave you and one that I have here on the board, is we're going to do a legal analysis of gender discrimination. What does the law actually say in regard to gender? And in doing that, similar to what we did with race discrimination, we say that there are generally 4 different eras in regard to gender discrimination. And the first one was legal discrimination. The second one is qualified legal discrimination. The third is legal equality. And the fourth is benign discrimination and affirmative action. And in talking about these, I just want you to recall what some of these terms mean. So when we talk about legal discrimination, what we're saying is that is the era during which it was perfectly legal to deny women rights based upon nothing more than their gender. It didn't have to do anything in regard to merit or abilities or physical disposition or mental disposition or anything else. You could just literally say that women do not have the same rights as men. And as we mentioned in talking about this in terms of the historical and cultural and social overview, despite the efforts of Abigail Adams and many other women, the United States Constitution did not provide any legal rights for women. They couldn't vote, they couldn't own property, they couldn't contract, and they had no rights even over their own children. In addition, they could be excluded from employment in many professions. And even if they were employed, the terms of their employment could be defined much differently and more narrowly than men. So when we talk about this era of legal discrimination, what we're saying is that women, from a legal perspective, were considered an inferior class of beings. Although that wasn't the exact language that was used by men to describe the status of women. Rather, men would say things like that, well, women are clearly different than men. They're the weaker sex. They're the more fragile sex. And they required special treatment morally, physically, and emotionally. I mean, heck, men said, we all know women are much more timid, don't have the disposition to do the same things as men. Right, Tiana? We all know Tiana's very timid, right? So clearly, this was the accepted perspective. After this legal discrimination stage, we say the United States gradually, and it is very gradual, as you'll see by the cases that we go over, enters into this phase of qualified legal discrimination, which said, okay, in general, women should have the same rights as men. But, and it's a big but we have to remember there are inherent differences between the sexes. And as long as a distinction is based upon these inherent differences, they can be treated differently. And they can be treated differently for their own good, for their own protection, for the well-being of our society. So that it's important for our society to treat women differently than men. And when we talk about qualified legal equality, most people point to the 19th Amendment and its passage in 1920 as demonstrating the beginning of that era, that there should be some legal equality. And as we know, the 19th Amendment was passed to provide the right to vote and saying that it cannot be denied by sex. Now, the interesting thing when you think about the 19th Amendment is the 19th Amendment didn't occur until 60 years after the 15th Amendment, which gave African American men the right to vote. Now, similar to the 15th Amendment, after the 19th Amendment was passed, some state and federal laws still limited the rights of women in many areas of our society, whether it had to do with employment, public service, education, finances. And that's, again, where they use this whole rationale of real gender differences. Physical weakness, disposition, reproductive organs, moral considerations. Then the third era we'll talk about legally is the era of legal equality, where the law evolved to a point where it asked the question kind of in a different way. The question became, is it ever viable to deny rights based upon gender? And the approach and the attitude was, this should only happen in the most extreme kinds of cases. And that any attempt by a public entity to treat men and women differently would be looked at with a suspect lens. So it was during that era that we believe men and women, for the first time, must be treated the same. And again, the question for women and the women's rights movement became, all right, once we achieve legal equality, is our quest for justice complete? And similar to race discrimination, women groups, National Organization of Women, for example, come to the conclusion that it's not. That again, just merely saying, okay, we have to treat you the same after they've been treated differently and repressed for over 200 years, wasn't going to make up for the disparities in status, wealth, finance, influence between men and women that existed at that point in our society. It wasn't going to go away. It had been institutionalized. So as a result, we have this era of benign discrimination and affirmative action, where women's groups say, okay, we don't just want equality of opportunity, we want equality of outcome. We want there to be requirements that employers must employ women, must promote women, must give them equal pay, equal status to men. So those are the major legal eras. And what we want to do is kind of give an overview of these things and then go over a series of cases like Bradwell versus Illinois, Minor versus Happeset, and these others that represent some of the legal thinking of the time. And remember that when the Supreme Court intervenes in some of these cases and makes decisions in some of these cases, that becomes the binding law of the land. So let's look at this first era. And as we said, in this first era, the United States Constitution did not provide any legal rights for women. None. And what we want to look at are cases that kind of represent that approach and philosophy many years after the passage of the United States Constitution. So if the Constitution is adopted in 1789, how long does this last for, where there's this ability to unilaterally deny women rights? So for example, again, hearkening back to race, we said that we did not allow African Americans legal rights until after the Civil War, with the passage of the 13th, 14th, and 15th Amendments in the late 1860s and 1870. And the belief by some women groups was, by definition, the dictates of, in particular, the 14th Amendment applied to women too. The Equal Protection Clause, the Privileges and Immunities Clause, the Due Process Clause, that all of these things, by definition, should apply to women. But what we'll see is the courts didn't really see it that way. So let's look at some of these cases. Let's look first at Bradwell versus Illinois. And just kind of as an aside, as I'm starting to go over these cases, one of the requirements for this class, when we should actually meet in class like normal students used to, God knows how long this will go on for, but when we met in class, I told you to take certain cases and you're going to present them to the class. Well, obviously we can't do that anymore. So just to kind of reiterate here, I am not going to require anybody in the class now to do class presentations about cases, and I am not going to require a paper, a research paper. Instead, what we are sending you is a list of, 5 movies? 5 movies that I am saying that what I want you to do is watch those movies and submit through D2L a 1 to 2 page analysis of those movies. And I am going to read you the name of those movies, and we're going to send this to you too, but I just want to give it to you in many formats as possible so that you can't say you don't know you're supposed to do this. So the movies are Bombshell, which deals with gender discrimination, Green Book, which deals with racial discrimination, Loving, which deals with racial discrimination, The Case Against 8, which deals with same-sex discrimination, and lastly, On the Basis of Sex, which is kind of an overview of a number of these kinds of issues. And that's the movie about Ruth Bader Ginsburg. So what I want you to do over the next 4 to 5 weeks is watch those movies and submit a 1 to 2 page analysis of all 5 on D2L, okay? And that'll take the place of the requirement that you do an in-class presentation on a case or an extensive research paper. And it also will help occupy your minds as you're held prisoner in your homes. All right. So to get back to what we were talking about, So we're going to look at some of these cases now and show you the legal implications and the legal approaches that were applied to ideas of gender discrimination. So let's look at Bradwell versus Illinois first. An 1873 case decided by 8-1. And the case, in terms of fact pattern, was about Myra Bradwell. Myra Bradwell had the audacity to want to be a lawyer. Imagine that. And she was seeking a license to practice law in the state of Illinois. And the Illinois Supreme Court denied her application for a license solely because of her gender. Bradwell said that this approach, this state law, denies her of her privileges and immunities as provided to every United States citizen under the 14th Amendment, and that the 14th Amendment says that a state cannot abridge the privileges and immunities of citizens. So it goes to the Supreme Court, and Justice Miller writes the majority opinion, and in the majority opinion, he says, "We agree that there are privileges and immunities belonging to citizens of the United States, which the states can't abridge. But the right to admission to practice in the courts of a state is not one of them." Why not? Well, they continue on. The claim that under the 14th Amendment, that Illinois can't set up barriers against women to pursue any lawful employment assumes it is one of the privileges and immunities of women as citizens to engage in any and every profession. And the court continues to try and show how this is an absurd conclusion. They continue, "It can't be affirmed as an historical fact that this has ever been established as one of the fundamental privileges and immunities of gender. On the contrary," the court argues, "the civil law, as well as nature herself," and they do say herself and not himself, "as well as nature herself, has always recognized a wide difference in the respective spheres and destinies of men and women." And they explain. They say the natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. So women just don't have the disposition to do a lot of jobs that men do. Right, Tiana? Right, Alexandra? Right, Kate? They say the harmony to the family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. The paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. So hey, don't you understand that's what you're really supposed to be? And that's all that's important is a wife and mother? You want to work too? What are you, crazy? And then they also conclude this by saying, this is the law of the Creator. So not only are they making this argument in the context of positive law, man-made laws, their interpretation of the 14th Amendment, but they're saying God has ordained this. So they're saying that their decision is also a product of divine intervention. Natural law. Remember natural law? What the heck's that mean? Well, this is an example. So what we're seeing here is, in 1873, well after the passage of the 14th Amendment, the Supreme Court is rejecting rights to women, saying they clearly do not fit within the context of the privileges and immunities that are supposedly understood and given to all people, especially when it comes to women. And we see this in other areas. So clearly in the context of employment. But then when you look at Minor versus Happersett in 1875, you see it in the context of voting. Voting. A 9-0 decision. So Virginia Minor tried to vote in Missouri. And the Missouri State Constitution confined the right to vote to men alone. Minor argues this violates the Equal Protection Clause. It violates privileges and immunities. What can be a more basic privilege and immunity in the United States than the right to vote? And the court says the following. It says, for nearly 90 years, the people have acted upon the idea that the Constitution, when it conferred citizenship, did not necessarily confer the right of suffrage. In other words, the right to vote. So, what they're arguing here is that the right to vote is not a privilege and immunity. It's not a fundamental right of citizenship. And Minor's arguing what could be more fundamental. The court continues on, and it says, it is within the power of the state to withhold suffrage. And as an example of this, the 13 original states gave the right to vote to men only. So they're saying, hey, we always did this, so it must be okay. They also say that no new state, to this point, had ever been admitted to the Union, which conferred the right of suffrage upon women. So, what they're arguing from a perspective of jurisprudence here is that, and this is an argument you'll see till this day in regard to how you interpret the Privileges and Immunities Clause, that if you want to know if something is a privilege and immunity that is then conferred to someone as a right based upon national citizenship, you have to look at history. What was our historical perspective on this issue? So what they're saying here is, well, look, when you look at it historically, we've always denied women the right to vote. So what the heck? How could it be a privilege and immunity if we've denied it all along, and to this point we've denied it? So 1875, we're still denying women unilaterally rights based upon one consideration: their gender. Well, after this decision, the women's rights movement again starts demanding change, but it wouldn't come quickly. So it took about 35 years, but beginning with the state of Washington in 1910, a number of states amended their constitution to extend the right to vote to women. To women. So things start slowly changing. Women start enjoying more and more rights. And the unilateral argument for complete legal discrimination, that it's perfectly okay to deny someone a right just because of their gender, and only because of their gender, is questioned. And it leads to this second kind of era, which is this idea of qualified legal discrimination. But what we'll see is it becomes kind of a matter of emphasis. What do I mean by that? A matter of emphasis. So in other words, you no longer look at laws or policies that are embraced by public entities that discriminate solely based upon gender and say, oh, that's okay, because we don't have to treat women the same as men anyway, we all know that. So that presumption starts to fade, especially as we go into the 1900s. And, you know, again, as I said, when we have the passage of the 19th Amendment. And there's more of a sense of, you can't just unilaterally dismiss people based upon their gender. But on the other hand, clearly we don't want to give women the same rights as men. So while we say that we're not denying them just based on gender, we've got to come up with another explanation. And the explanation becomes some sort of argument along the lines that, well, guess what? There are significant differences between men and women that justify treating women differently. Women saying that justify you discriminating against them. I say, it's not discrimination. That's not discrimination. If because of some real differences between men and women, we have policies that recognize that and treat them differently. So what we're saying is, the question becomes how and why can you treat women differently? So during the 20th century, despite constitutional amendments, the federal courts continued to approve limitations on women in regard to employment and full participation in citizenship. As we said, the 19th Amendment was seen by women as a significant achievement that should have led to the advent of total legal equality. The courts don't see it that way. So even after the 19th Amendment was passed, the courts held that the 19th Amendment does not imply that the 14th Amendment applies unilaterally to gender discrimination. And it doesn't imply that the 14th Amendment secures legal equality for women. Now, does it influence the 19th Amendment, the interpretation of the 14th? Yes, to some degree. but not to this degree that women's rights movements claim that it should. So as we said, the question became not can we just unilaterally deny rights to women, because there was a sense, okay, we can't do that anymore just based upon gender. But the new question becomes, how can the rights of women be limited in light of legal efforts to promote supposed gender equality? Now, meaning gender equality to the extent that we think men and women are equal. Clearly, the perspective during this era, they're still not really equal. So there's a number of cases that deal with the issue of workplace gender discrimination. Now, we already talked about how in Bradwell versus Illinois, the state of Illinois just unilaterally denied women the right to practice law. And by the way, many law schools had policies denying the admission of women to law schools. Harvard denied the admission of women into their law school till the 1960s. They said it would be a distraction to serious male students. So let's look at some of these cases. Let's look at the workplace. What we see when we look at workplace laws was that numerous states had laws setting maximum work hours for women versus men, and also prohibiting night work and various participation approaches for different types of occupations. So it was very common to have different standards for men and women. And it leads to a series of pretty interesting cases. So we have Muller versus Oregon in 1908. And in this case, it dealt with the state law that said no woman could work more than 10 hours a day. Now that again just applied to women. Men could work as long as they felt like it. So Carl Muller operated a laundry business called Grand Laundry. And he required all of his employees, including women, to work more than 10 hours a day. So, he's cited for violation of Oregon law. He's found guilty of violating Oregon law. He is fined